From distant lands we gather, hearts of fire all along. Oh, big Nick calls we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick calls we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Hey, oh, folks! Ooh, Tuesday. Oh, yeah. This stream should have happened yesterday afternoon your time. But something came up, couldn't do it, so I'm doing it now instead. And I'm a bit bummed out because, as it turns out, it was the first of one of the other people in the car who took the stand. It is the driver of the car who I don't think I will do. Will be a spoiler because it's in the thumbnail. It turns out that this is the woman in the car, the alleged driver, who at the time was a stripper. Yeah, or adult dancer or exotic dancer. Say what you will about it. Who, according to herself, was both cocaine and marijuana user and other stuff. She was also of legal age, which Tay-K wasn't. Can anybody say statutory rape? But, well, she will take the stand and she will try to testify, because after she's done and the trial is done and the prosecution says she did good, she's free. Well, she has some probation left, but other than that, she's free. Yeah. If you haven't seen it, I will let you see it first. What she pled to and what the original charges were. So, let's get a banner up. Yeah, okay. First of all, we have, so far, 19 sidebars and 5 motions for mistrial in this trial. I have a strong suspicion there will be more. Oh. Let's see here. Let me get this. Banner up. Save. There. Banner is up. Banner is up. And here they are. Here they are. Yeah, let's get right into it.
Nicole, 2019 CR 12495, State versus Tamar McIntyre. Can I have parties announced for the record?
Yes, Jason Gearhan and Megan Galloway for the state, Your Honor.
John Hunter, Jerry Goldstein, and Thomas Lane for Mr. McIntyre, Your Honor. I believe he's still back in holding.
Oh, he's back in hold. All right, we'll wait for him. Getting dressed. Okay. .
Yeah, let's say hi to. Let's see. Hello, Gwendolyn. Hello, Gigi. Snivels is here. J.K. Debug.
All right. And you're Mr. McIntyre? All
Teresia.
right. So are both
Thank
parties
you for
ready to
being
proceed?
here. Barry Anchor.
Oh, no, I think they're bringing the witness, but y'all are ready to proceed with
Yes,
trial
yes, yes.
once. All right. So I'm being told that all of the jurors are here.
Great, thank you, Judge.
And hello, you guys over at Rumble, of course. Good to have you here. And hello, you over at X who is tuning in.
And Jenna? I'm gonna
This
start
will
inputting
be
the system, so
really
once I finish, I'll
interesting
just put them up here. All right,
with
thank you.
this person taking the stand. Yeah. And
Oh, you need a seat? Yes.
and they will lead her in.
Is there an extra chair?
She's not coming in from. She's been in holding as well because she's been incarcerated awaiting her testimony as well. Well, she's been out on bond, but they brought her in just to make sure she took the stand.
For the attorney?
Hi, Starfish. Hi, Mr. Man.
Get one for the bathroom, Judge?
Oh, yes.
Here, I can grab one from my office.
All right, we can take that one, I think.
It's a rolling chair, sir.
All right. Counsel, you're okay with the rolling chair?
Of course. I can grab one from the witness room.
Oh, here's one here.
Move on.
Okay. Thank you, Norma.
No, she is very nervous.
Oh, we have one. Thank you.
She is very, very nervous, and I understand why. Because if she fails, they might charge her for capital murder. Barry Anker says, Nick, have a great interview for you from Savage Freedom's Defense. Adam Smith, Redneck Air Force Commander during WNC. Send it. Gigi posted my email. Send it to me, and I will check it out. Right, now we can...
That the person sitting next to them is their attorney. All right. All right. And both parties are ready to proceed?
Yes, sir.
Yes.
Yes, Your Honor.
Okay. All right. Let's bring the jurors in.
All right, for the jury,
All right. State, call your next witness.
the state calls Joanna Reyes.
All right, can you raise your right hand for me,
Joanna
please? Do you
Reyes.
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, state your name for the record, and spell your last name, please.
Joanna Reyes, Reyes.
All right. State, you may proceed.
Joanna, will you please introduce yourself to the jury?
My name is Joanna Reyes. I am a hairstylist and I also work at a warehouse.
And how old are you currently?
27,
And what city do you currently live in?
San Antonio, Texas.
I'm sorry, Your Honor. Is there any way we could raise the microphone's volume on the
Okay.
witness?
Just one moment. Can you
Hey,
make sure
Vic.
that you keep your voice up so members of the jury can hear, so that everyone can hear?
Oh, he wants to
Speak into
talk,
the
speak to
one
someone who does
microphone,
podcast and
Yes,
YouTube
ma'am.
content. If it's not a
Alright,
part
what
of
city do you currently live
any case
San
I
Antonio,
actually
Texas.
follow,
And
but
about
send
how
me the
long have you
case,
lived in San
at
Antonio?
least.
Since
Send me the
2005.
case, or who he is. Send
Where were you
information.
born?
Libertyville, Illinois,
And about how old were you when you moved down to San Antonio?
10.
What side of town did you grow up on?
Marbach area, 410.
And did you attend high school here in San Antonio?
Yes, ma'am.
What high school is that?
John Paul Stevens High School.
Okay. And did you graduate from that high school?
Yes, ma'am.
Did you graduate from that high school or did you obtain your degree somewhere else?
I did homeschooling.
And is that how you were able to obtain your high school diploma?
Yes, ma'am.
Do you know why you're here today?
Yes, ma'am.
Why is that?
For the case to get justice for Mark Anthony Salvador.
Have you taken responsibility for your actions on the
Calculating.
day?
And let me hear the question, and then I'll rule on your objection.
Have you taken responsibility for your actions on the day that Mark Saldivar died?
All right, the objection will be overruled.
You can answer the question.
I think that is very, very, very bolstering.
I pled guilty to tampering with evidence.
Okay. So you entered a plea agreement with the state of Texas?
Yes, ma'am.
Yes, folks. She was charged with capital murder, and she was allowed to plead out to tampering with evidence. Yeah. That's how desperately the state wanted witnesses. They could have had her for, I don't know, manslaughter, many charges. Many charges. Many charges. Remember, she was 19 at the time and decided to date a boy who were, I don't know if he had his 16th birthday yet. Maybe in Texas that's not let me check that out while we listen here.
Now, regarding that plea agreement, originally you were charged with capital murder. Is that correct?
Yes, ma'am.
Okay. And you worked out a deal where you ultimately pled to the offense of tampering.
Age of consent in Texas is 17. And Tay-K was not 17. She was 19 when they started dating. So, yeah, they didn't charge her for that.
Tampering with evidence, is that correct?
Yes, ma'am.
And for tampering with evidence, the range of punishment is 2 to 10 years in the prison or community supervision.
Your Honor, I'm going to object to leading.
Sustained.
And I ask the jury to disregard the question and the answer, and the court would entertain it. All the questions and answers between my first
Yeah, you're not supposed to say what the possible sentences are for different crimes.
objection and now.
No, I will not entertain objections that I've already ruled on. Ladies and gentlemen, the last question and the last answer, you are to disregard. Does everyone understand? All right, State, you may continue.
So I'm showing you what's been marked for identification purposes as State's Exhibit number 117. Do you recognize this document?
Yes, ma'am.
And does this document contain your name? Yes or no?
Yes.
Okay. And does this document also contain your signature?
Yes, ma'am.
Okay. And on this document, is it a fair copy or true copy of your plea agreement that you entered?
Yes, ma'am.
Okay. So you can use this to refresh your memory if you need to. Just don't read it. Okay.
Yes, ma'am.
Your Honor, given that it's a certified copy of a judicial document, the defense would move to admit that exhibit.
Well, if you want to admit that exhibit, you need to do it during your cross-examination of the witness.
Yes, Your Honor.
Thank you.
Well, Judge, since they're not going to object at this time, the state offers State's Exhibit number 117.
Any
No
objection?
objection.
All right, State's Exhibit number 117 is admitted without objection.
May I have permission to publish, Your Honor?
Granted. And I'm sorry, I don't know if the screen is working or not. Thank you.
All right. So, Ms. Reyes, I think where we left off was what was the range of punishment for the offense of tampering with evidence. Are you able to see the document up there on the screen?
Yes, ma'am.
Okay. Do you know what the range of punishment is for that offense?
Yes, 2 to 10 years, possible fine up to $10,000 if the offense occurred on or after September 1st.
And do you know what, well, I guess. And as part of your agreement, what was the punishment that was agreed upon that you were to be sentenced to?
Tampering with evidence and attempt to impair.
Okay. And just regarding line 3, do you know what the state's recommendation for your punishment would be?
Yes, ma'am. 10 years deferred adjudication on the offense of tampering with evidence.
And then regarding line 4, what did the state ultimately do with the pending capital murder charge?
The state will dismiss the pending capital murder charge against your client at the time of.
And did you have other cases pending at the time that were dismissed?
Yes, ma'am.
And this plea agreement was made to you in exchange for what?
Truthful testimony.
And so have you been
This
on
is a
bond
bit more
for- let me
bolstering,
step back a little bit.
but
Do you know what day you entered this plea agreement with the state?
December 18th, 2018.
Okay. And have you been on bond in your case since that date?
Yes, ma'am.
Yeah, so she agreed to testify 2018, December 2018. For 5.5 years, they have dragged this case on. 5.5 years. Mr. McIntyre has been incarcerated for, well, he was on the run for a while, but I believe it's close to 7 years in jail.
Do you know what the conditions of your bond are?
Yes, ma'am.
What is that?
No contact with any of the defendants for the family in Marquette, Salvador.
Now I want to talk to you about the month of April 2017. Do you recall who you were hanging out with during that month?
Yes, ma'am. Tamor, Jalen, Isaac, Jeremiah, Desiree,
Tamor, what is his last name?
McIntyre,
And what is Jalen's last name?
Bell,
Do you know Isaac's last name?
Ibarra,
And do you know Jeremiah's last
Rodriguez.
name? Okay.
These
specifically
are the
regarding
people
Tamor
in the car.
McIntyre and Jalen Bell. Do you recall where you met them?
At a gathering at Isaac's house.
Okay. Have you met him before that day?
No.
You had never met him before that day?
Is it Jeremiah?
No, sorry. Let me clarify. So regarding Tamor McIntyre, you previously stated you met him at a gathering at Isaac's. Is that correct?
Yes.
Okay. Had you met Tamor McIntyre before that day?
Yes.
Okay. Do you know about how far ahead?
I'm not too sure on the timeline, but I believe it was a year or a year and a half prior.
And how old were you in 2017?
18.
Did you know how old Tamor McIntyre was at that time?
No, he just said that he was 18.
Were you in a
Would you take that as an answer if the roles were reversed? A legal adult just taking the word for somebody who is younger? Would you have, folks, just a show of hands, how many of you would accept in a legal setting, oh, she said she was 18, and then you look at the person and Tay-K, at the time, he did not look like an adult. If the roles were reversed, what would you have said?
relationship with Tamor McIntyre?
So he says,
And how would you refer to you as?
his girlfriend.
And during this time period, were you all staying together for living purposes?
Yes, ma'am.
Where would you guys sleep?
Multiple people's houses.
Okay. Can you name some of the people's houses that you would stay at?
But it was Isaac. We stayed at Jeremiah's. He had a friend in Killeen.
Objection, relevant.
Relevance.
Well, Judge, it's laying the predicate for testimony to come, but I'll move on.
Can we approach, Your Honor?
Yes.
Now, this is not unusual. They are trying to paint her in as good light as possible. And that's perfectly normal. And sidebar counter 20! That was a quick sidebar.
All right. State, you may continue.
Thank you. Now, regarding Jeremiah Rodriguez, how did you know Jeremiah?
We had went to the same school, students.
Okay. And so, for about how long did you know him before May of 2017?
Not too long, maybe a couple years. I knew of him. I never really hung out with him.
Okay. And in April of 2017, did Jeremiah Rodriguez have a girlfriend?
Yes.
Do you know what her name was?
Desiree.
Okay. During this time in April of 2017, what were you doing for work?
I was an entertainer.
And when you say entertainer, can you kind of further explain?
I did work at the strip club. from ages 18 until probably 23.
Now I want to talk to you about Mark Saldivar. Did you know him?
No, I just knew him on Instagram.
Okay. Based on your knowledge of him on Instagram, do you know what his hobby was or what he liked to do?
Photography?
Okay. At some point in April 2017, did you come into contact with Mark Saldivar?
Yes.
Do you recall how you did that?
Through Messenger?
Okay. Was that on Instagram?
Yes, ma'am.
For what purpose did you come into communication?
Timor wanted to make an album cover for his new song.
Okay. And so specifically, why did you reach out to Mark Saldivar?
For that photo shoot.
Okay. You said new song. What was Tamor's name that he would release songs under?
Tay-K 47 or Tay-K.
Okay. And regarding Jalen Bell, did he have any nicknames that he would go by?
Pimpies or yeah.
Okay. Now, why was Mark Saldivar picked as the person to do the photo shoot?
Because he was offering to do it at low cost or no cost at all.
Okay. And were you supposed to be part of this photo shoot?
Yes.
Do you know what the plans regarding you were for the photo shoot? What were you supposed to be doing?
I was supposed to be in lingerie and with props of guns and marijuana and with a mask also.
Okay. And making the plans for the photo shoot, who was communicating with Mark?
It was me and Timor.
Folks, this is the prosecution, direct examination. This is the cleaned up version. I can guarantee this is not how it will be described during cross-examination. But we have to check this out first.
Okay, and when Tamor was communicating with him,
Hi,
whose
Loco.
phone was he using?
Mine.
Okay. So at some point, did Mark Saldivar agree to be the photographer for this photo shoot?
Yes, he did.
And so
I
on
need to
April
fill up my
23rd of
coffee. I'll be right
2017,
back.
Do you recall where you started the day off?
At Jeremiah's.
Is that Jeremiah Rodriguez?
Yes, ma'am.
Okay. What kind of car did you have at that time?
A black Kia Forte.
Okay. Who was that car registered to at the time?
My father.
But who was the one that was driving it?
I was driving.
All right. Do you recall how your hair was on that day?
I was wearing a blonde wig.
And what did you have planned to do that day?
Just a photo shoot.
And who were you with for the photo shoot?
Tay-K and Jalen and Jeremiah.
All right. Did you guys go anywhere all together?
Yes.
Where?
To Mark's house.
And what vehicle did you all use to go to Mark's house?
My vehicle.
Okay. And who was the driver? Or when you guys got into your vehicle at Jeremiah's house, who was in the driver's seat?
I was.
And who was in the front passenger seat?
Tamor.
Who was sitting in the back directly behind you?
Jeremiah.
And who was sitting in the back directly behind Tamor?
Jalen.
Do you recall what color shirt Tamor was wearing?
White.
And just, can you explain Tamor McIntyre's appearance? As far as his skin color, how would you describe him? Do you know what his race is?
Yes.
What is that?
African American.
Would you describe him as a light or dark skinned African American?
Dark skin.
Okay. And regarding his height, is he tall or short?
At the time, he was my height.
And was regarding
At the time, he was her height. Yeah, because he was a kid who was still growing. You pedo.
his build, was he skinny or chunky?
Skinny.
Now, regarding Jalen's appearance, or do you know Jalen's race?
No.
Regarding his skin color, how would you describe his skin color?
Light complected.
Okay. And regarding his height, is he tall or short?
Tall.
And was he skinny or chunky?
Chunky.
And regarding Jeremiah, do you know what his race is?
Hispanic.
Okay. And was he short or tall?
Tall.
And skinny or chunky?
Skinny.
And Did he have short or longer hair?
longer.
Now, you stated previously that you all went to go pick Mark Saldivar up. Do you recall where you all picked him up at?
His house,
Did you pick him up directly in front of his house or down the street from his house?
possibly diagonal.
Okay, so not directly in front of his house.
No, no.
Do you know if Mark Saldivar had anything with him when he got into your vehicle?
Objection leading.
Overruled.
You can answer the questions.
He had a bag with him.
Okay. Do you know what was in the bag?
No,
Okay. Did he have anything else with him?
his camera.
Okay.
Objection leading.
Overruled.
Do you know what kind of camera it was?
It was a white Canon.
Now,
And here we go again. A witness, 8 years later, being able to describe this in this kind of detail. Isn't it remarkable how a prosecution's witnesses can be so such detail.
once Mark Saldivar entered your motor vehicle, who was sitting in the driver's seat at that time?
I was
Who was sitting in the front passenger seat at that time?
Tamar,
Who was sitting directly behind you at that time?
Jeremiah,
And who was sitting in the middle of the back seat?
Jalen,
And who was sitting directly behind Tamar?
Mark.
Mark was sitting directly behind Tamar?
Yes.
Okay, thank you. And so after you picked up Mark Saldivar, where did you guys go?
He asked us if we could reschedule for the day and if we could give him a ride to North Star. So I agreed and I said, okay, that's fine.
Okay. And so you were still going to give him a ride to North Star Mall.
Yes, ma'am.
Okay. And so on the way to North Star Mall, what happened?
We hit the light at McCullough and Tamar took out his gun and pointed it at Mark and asked for his bag. Mark refused to give him the bag. So they all started hitting him and Tamar was hitting him with the gun. And the whole time I didn't look back, but when I did, I saw his face. And I started telling them to let him go. And I just kept screaming, let him go.
Objection hearsay.
Overruled.
And Jalen opened the door and started pushing him out. And he was fighting to get back in the car. And then I didn't let him in the car. So he went around the car and he jumped on the hood. And the light turned green.
I'm gonna stop you right there, okay? So when you all were at the light on McCullough, you said Tamar produced his gun, correct?
Yes.
And who did Tamar have the gun pointed at?
Mark,
And what was Tamar saying when he had the gun pointed at Mark?
to give him his bag.
And so once the light turned green, what happened?
He put it with an enemy and told me to start driving. So I started driving. I didn't know where to go. So I turned into the first place that I saw, which was the Chick-fil-A. Once I turned into the Chick-fil-A, he kept yelling at me to get him off the car. I didn't know how to, so I was just going back and forth really quickly. And then Mark kicked the windshield and Tay-K opened the door and shot him. He just
All right. So when you were in the Chick-fil-A parking lot, and Mark was on the hood of the vehicle, who was sitting in the front passenger seat of the vehicle?
Tamar.
What did you observe Tamar McIntyre do from the front passenger seat?
He shot him.
How did Tamar, did he exit the vehicle or did he roll the window down? How did he shoot?
Yeah, he opened the door and leaned out on one leg.
Now, do you see the person that shot Mark Anthony Saldivar in the courtroom today?
Yes.
Would you please point to him and identify him by an article of clothing he's wearing?
In a white shirt.
Thank you. Let the record reflect that this witness has identified the defendant, Tamar McIntyre. Now, I need to back up a little bit, and I apologize. When you all were at, where did Mark's backpack end up?
And Jalen had it.
Well, I'm gonna back up a little bit back to the stoplight on McCullough, okay? Did Tamor ever gain Mark's backpack at any point?
Yes.
Okay, and when was that?
And when they were fighting him.
Okay, and regarding where was the backpack once you all were in Chick-fil-A? Do you know where it was, or you didn't see it at that time? I didn't see it. Okay. Now, when you all were at that stoplight at McCullough and 410, prior to that, did you have any knowledge of Tamor's intentions to take Mark's belongings at gunpoint?
No, ma'am.
Okay, but then what did you observe occur?
He was robbing him.
And that's at the stoplight.
I will not give spoilers. I'm just going to say cross-examination will be interesting.
Yes.
When you all, well, I'm gonna publish State's Exhibit. State's Exhibit number 63. Now, is that a fair and accurate representation of the events as they occurred on the offense date?
Yes, ma'am.
Permission to approach the witness. Your Honor.
Granted.
I'll show you what has been marked, State's Exhibits number 119 and State's Exhibits number 120. Have you seen these before?
Yes, ma'am.
And do you recognize the items that are contained within State's Exhibits 119 and 120?
Yes, ma'am.
And are they fair and accurate depiction of the items as they were on offense date?
Yes, ma'am.
Enter into defense for inspection and offering States 119 and 20.
Objection 403 and renewing our previous objection 702 and 3914 to the state's presentation of what is it, 64 with the video.
They are objecting here because this, I believe, is the third or fourth time they have shown this video when the victim was shot. And for me, yeah, this is getting close to how many times, because it's already been admitted, it's already been shown, in third or fourth time. At what point does it get excessive? A 4 or 3? And we have a sidebar. Sidebar counter 21. 21. Let's skip ahead until the end of.
Permission to publish, Your Honor.
Granted.
Yeah, as Starfish and Coffee says, cumulative.
Now regarding exhibit number 119, are you able to see that up there, Ms. Reyes?
Yes, ma'am.
All right, and can you please explain to the jury what I'm pointing at right here?
That's me.
And is that your motor vehicle?
Yes, ma'am.
And what seat are you seated in?
The driver's seat.
And regarding CX 120, we have approach. Regarding state exhibit number 120, can you explain to me what's going on with the back passenger window right there?
Jeremiah has it rolled down.
Now, after the defendant shot Mark Saldivar in the Chick-fil-A parking lot, where did you go? What happened?
He wanted me to keep driving. He didn't want the cops to get there. So he had directed me through the window to drive. And I went down the access road and took the first left and stopped at a Mexican restaurant.
I'm gonna back up a little bit before we get to the Mexican restaurant.
Half spoiler. One thing that she hasn't said yet is these other two guys in the car. She hasn't really described how, if, who knew who. And that will be shown during cross-examination, who actually knew who in that car.
Was Mark Saldivar ever shot inside of your black Kia Forte?
No, ma'am.
At any point, did you see Mark Saldivar with a weapon on him?
No, ma'am.
To your knowledge, did anyone else in the vehicle have a firearm?
Jalen.
Now, this they say to remove the self-defense aspect of this trial. Now, in my opinion, you don't you don't have to have a gun. It just doesn't have to be a gun involved for it to be self-defense. I believe the standard in Texas is greater bodily harm. And I'm not sure if the defense will go with that defense, but it is an aspect of their defense.
But who was the only person that you saw with a firearm in the motor vehicle?
Seymour.
And so when you get to the Mexican restaurant, what happens?
I parked the vehicle. And then they started getting out of the vehicle. And then I got out of the vehicle and they were going through the backpack and then also going through his wallet, throwing things out.
Okay. I want to back up a little bit. Do you recall who got out of the vehicle first?
Seymour, or no, Jeremiah.
Okay. And then after Jeremiah got out of do you know where Jeremiah went once he got out of your vehicle?
No,
Did he ever come back and meet with you there at the Mexican restaurant?
no.
Okay. And then who got out of the vehicle after Jeremiah?
I agree, Gigi. How the fuck did he end up with weed in his
So You
mouth?
said, do you know where Mark Saldivar's backpack was at this time?
Jalen had
Okay. And regarding Mark Saldivar's belongings, who did you observe with Mark Saldivar's wallet?
Jalen.
Do you know if there was anything inside of the wallet?
Yeah, I got upset because there was only $10.
When you say he got upset, who are you referring to here?
Jalen.
Can you please describe to the jury the demeanor of Tamor McIntyre and Jalen Bell at the Mexican restaurant once you all got off of the vehicle?
They were kind of going back and forth, and then Jalen applauded him and gave him a high five in front of each other. And Jalen said, "You caught your first body."
Can you describe to the jury how you were feeling when you all were at the Mexican restaurant?
Shock.
Did you ever see what was inside Mark Saldivar's backpack?
No,
Did the defendant, Tamor McIntyre, ever make a statement to you about what was contained within the backpack?
yes.
What was that?
He said there was a roll of condoms, a bottle of lube, and a whole other outfit.
Still amazed on how detailed she can be 8 years later.
Or did anyone make a statement about Mark Saldivar's cell phone?
Jalen,
You know what he did with the cell phone?
He said he tossed it.
Objection, hearsay, confrontation.
Judge, it's a party opponent, statement by co-conspirator and further.
Mr. Bell is not a party opponent.
The objection will be sustained.
Move to instruct the jury to disregard the question and whatever part of the answer got out.
All right, ladies and gentlemen, you'll disregard that last question and last answer.
And motion for mistrial.
Denied.
This will be motion for mistrial number 6. And here I'm starting, I'm being annoyed at the prosecution because they have elicited the same type of answer. What did he say? What did they say? They have been doing that a lot during this trial. And let's just say I'm not a fan of that, simply because it's hearsay. The exception doesn't apply. And the prosecution knows this. And they still do it.
All right, Ms. Reyes. Now I'm going to show you some photographs. Starting with State's Exhibit number 88. Do you recognize what that is? What is continuing with State's Exhibit number 89. Is there anything significant contained within this exhibit?
The picture.
All right, so this item that I'm pointing at, what is that?
A picture of Taylor and me.
And State Exhibit number 93. Do you recognize what that is?
My toothbrush.
State's Exhibit number 94. This item that I'm pointing at, who did that belong to?
Taylor.
And this item that I'm pointing at, who did that belong to?
Taylor.
State's Exhibit number 95. The item that I'm pointing to, who did that belong to?
Taylor.
It's not like the judge is allowing. It's that she
State's Exhibit
doesn't.
number 99.
The motion. She denies the
This
motion
item
of
that I'm
mistrial.
pointing at, do you know who it belonged to?
This is the Jabins or Taylor's.
But again,
Yeah,
it's
regarding,
at what
State's
point
Exhibit
does
number
it
102, the item
become
that I'm pointing at,
overly
do you recall who that
obvious
belonged to?
that they have this as a tactic?
Uh, Yeah, regarding State's Exhibit number 115, do you know who that belonged to?
Taylor.
Now after you all want to publish State's Exhibit number 63.
Have you hit the thumbs up yet? Please do. It really helps the channel. And if you haven't subscribed yet, please do. And if you think you are
State's Exhibit number
subscribed,
63, can you see that?
please check, because people get unsubscribed from my channel. Even though they have been subscribed for years, they still get unsubscribed from time to time. So please check that as well. Tater salad. Agreed. Would this be grounds for mistrial? I think hearsay being allowed in over and over would be grounds for that. Yeah, but most of the time, the judge's instructions in this is regarded as enough, because the the jury is supposed to be Yeah, okay, we will forget about that. But at what point, when it becomes obvious it's a tactic from the prosecution? At what point? Because this has to apply for everyone. It doesn't matter if it is shoplifting or capital murder. It's not that hard to follow the rules.
Do you know who that is?
Jeremiah.
On State's Exhibit number 63, as displayed where my mouse is toggling, do you know who that is?
Jeremiah.
Again, where my mouse is toggling on State's Exhibit number 63, do you recognize who that is?
Jeremiah.
My mouse is toggling. Do you recognize who that is? I'm going to show you what has been marked as State's Exhibits number 121 through 127. Inclusive. Have you seen these before?
Yes, ma'am.
Do you recognize the items that are contained within the State's Exhibits?
Yes, ma'am.
And are they a fair and accurate depiction of the items as they were? Actually, offering States 121 through 127 inclusive.
I agree with Tater Salad here. It's hard to unhear things. Reminds of the thug trial. Yeah, not to that extent, but still.
Yes.
And we have another sidebar. Sidebar counter 22. Woo! I have to update this one. Sidebars 22. Motions for mistrial 6. I told you there were going to be more sidebars.
Do you recognize, right, Ms. Reyes, if you could take a look at State's Exhibits 121, do you recognize this item that I'm pointing to?
Yes, ma'am.
Okay, and what is this area?
The trunk of my car.
Okay, and the items that are contained within State's Exhibit number 121 are these items that were left in your motor vehicle?
Yes, ma'am.
And do you recognize them to be in the same condition as they were when they were left in the vehicle?
Yes, ma'am.
State offers 121 through 127 inclusive.
All right.
No objections, Your Honor.
All right. Objections are noted. They'll be overruled. States Exhibits 121 and 127 are admitted.
Permission to publish.
Granted.
Did you say and 127?
Well, 121 through 127.
Now, Ms. Reyes, regarding State's Exhibits number 121, you've just explained, but can you explain to the jury what's depicted in this State's Exhibit?
My car.
In State's Exhibit number 122, do you recognize what is contained in the State's Exhibit?
Yes, ma'am.
And what is that?
St. Louis, Jersey.
And State's Exhibit 123, do you recognize the item contained therein?
Yes, ma'am.
Okay, this item that I'm pointing at, what is that and who did it belong to?
St. Louis, Virginia.
And regarding the item that I'm pointing to in State's Exhibit 123, do you recognize it?
Seymour and Jailer share the shirt.
Regarding State's Exhibits number 124, the item that I'm pointing at, do you recognize it and who did it belong to?
Seymour.
State's Exhibit 125, do you recognize that?
It's mine.
State's Exhibit 126, do you recognize that?
Yes, that's mine.
And State's Exhibit number 127.
Seymour's.
Now, after you all are at the Mexican restaurant, did you all go somewhere after that?
Yes.
Where did you all go?
And there was a Starbucks right next door. And we went there while Seymour was on my phone and he got a ride.
And where did you get a ride to, if you recall?
Jeremiah's house.
And when you all left the motor vehicle there at the Mexican restaurant, did you have any intention of returning back to the vehicle?
No, ma'am.
And you said that you all were going to Jeremiah's house, is that correct?
Yes, ma'am.
Was that Jeremiah Rodriguez?
Yes, ma'am.
Okay. Did you all go to Jeremiah Rodriguez's house?
Yes, ma'am.
And did Jalen and Jeremiah stay, or did Jalen and Tamor stay there at Jeremiah's house?
Yes.
Okay. Where did Jalen and Tamor go from Jeremiah's house?
They got a lift.
Just one moment. When an objection is made, don't speak because I'll need to rule on it, the objection. All right, ask your question and then you can make your objections and the court will make a ruling.
Do you know if Tamor and Jalen went anywhere after being at Jeremiah's house?
Objection, hearsay.
That'll be overruled.
You may.
Yes, ma'am.
And just so the jury's aware, were you there at Jeremiah's house after you all left the Mexican restaurant? Who all was there at Jeremiah's house?
It was me, Jeremiah, his family, his mom, Tamar, and Jalen.
And so while you all are there at Jeremiah Rodriguez's home, where did Tamor and Jalen go from there?
They said they were getting a lift to Austin.
Objective, hearsay again.
All right, and who, I'm sorry. With regards to hearsay, if that's something someone else said, then the objection will be sustained.
Motion to instruct the jury to disregard the answer.
All right, ladies and gentlemen, you're instructed to disregard the answer
Motion for mistrial.
tonight.
All right. Did you observe
Motion
Tamor
for
and Jalen leave
mistrial
Jeremiah
number
Rodriguez's residence?
7.
And did they have any of Mark's belongings when they left?
Yes.
Do you recall what belongings and Mark's they still had?
The backpack and the camera.
Did you stay the night at Jeremiah's house, or where did you go after being at Jeremiah's?
No, I begged someone to take me home, which was his dad.
And did you have somewhere to be that next morning?
Yes.
Where was that?
Or,
Did you go to court the next morning?
yes, ma'am.
And so the day after the offense, you were in a court with bailiffs. Did you speak out then?
No, he was too scared.
And after court, where did you go?
To Dallas.
When you arrived in Dallas, who were you staying with?
Taylor's sister,
Do you know her last name?
Beverly.
Do you recall what apartments you were, or what type of location you were staying at with Kayla?
They were apartments.
Okay. And do you recall what they were called?
No, but I remember the address.
Okay. And what is that?
2424 Henderson Drive.
Is there anything significant about the location that sticks out to you?
In the area across the street, there was a plaza, which I remember there was a Kroger and a beauty supply. And then next to it on the left side, there was a gas station.
Okay. Did the apartment that you were staying at, did it have a balcony?
Yes, ma'am.
And is there anything significant about the door on the balcony?
Yes, the color of it.
Do you remember what color it was?
Looks like a red orange.
Now, shortly thereafter, after the offense occurred, did you learn information that a detective with the San Antonio Police Department was trying to get into contact with you?
Yes, ma'am.
What did you do when you learned this?
His sister Kayla told me to lie to the detective and say that the car was stolen.
Objection, hearsay, Your Honor.
Sustained.
Move to instruct the jury to disregard the question and the answer.
Ladies and gentlemen, you are to disregard the question and answer.
And motion for mistrial.
Denied.
Okay.
Yeah. Again, the prosecution knows not to ask questions to elicit this kind of answer, and they keep doing it. Now for me it's apparent this is their tactics. Make the jury hear it. I admire Judge Boyd. I really do. But at what point does this become ridiculous? We are now at motion for mistrial number 8. Now all of these motion for mistrials are for appellate issues. It is extremely hard to get a ruling motion for mistrial for the defendant. Extremely hard. But they have to do it to protect the record, and if convicted, it's appellate issues.
So without repeating what anyone told you, did you speak with the detective over the phone?
Yes, ma'am.
Did you tell the detective anything about your motor vehicle?
Yes, that it was
Objection,
stolen.
hearsay.
Overruled.
You reported to the detective that it was stolen,
Yes, ma'am.
but that was not true, was it?
No, it was not,
Okay. Why did you tell the detective that?
because I was told to do so.
Objection, hearsay.
Untimely.
Now, when you
Objection overruled, Your Honor.
Yes.
when you first spoke with the detective and told him that the car was stolen, did you make an appointment to speak with him in person?
Yes, ma'am.
Did you ever show up to that appointment?
No,
Why not?
because the day before, they made me work at the club at Temptations, and that night, when I fell asleep, they stole everything out of my bag, my money, my ID, my social, everything.
And did you ever talk to the detective again?
Yes,
Did you tell the truth at that time?
No.
Why not?
I was scared
Why were you scared?
because I thought I was gonna get hurt.
Why did you think you were going to get hurt?
Objection calls for hearsay.
All right. You're not allowed to say what anyone else told you. There are certain exceptions to hearsay. I don't know if this would fall under one.
Why were you scared that you were going to get hurt?
Because anytime I didn't listen to Kayla, she would call Tay-K.
I'm sorry. The objection to hearsay will be sustained.
Your Honor, I'd ask the jury to disregard the answer.
Ladies and gentlemen, you disregard the answer.
Motion for mistrial.
Denied.
Whenever you're stating that you were in fear, is that correct?
Yes, ma'am.
What did you observe anything that placed you in fear?
Yes, he killed somebody.
And did the defendant ever make any statements to you about your family personally, and
Yes,
and what were those statements?
and he would kill me and my family.
And is that why you were also in fear?
Yes,
Now, do you recall about how long you stayed in Dallas?
Now, if
I'm
you
not too sure on the time.
if you wonder, well, why wasn't that hearsay? Because he is a party opponent. So there's an exception for that.
At some point did you leave Dallas, Texas?
Yes,
Where did you go from Dallas, Texas?
Odessa.
And when you were in Odessa, were you away from the defendant and his sister?
Yes, ma'am.
Did you choose to speak out then?
No.
Objection. I'll withdraw.
Why not?
I'm still so scared.
And then ultimately, when you were in Odessa, were you arrested for a warrant?
Yes, ma'am.
Okay. And once you were placed into custody, did you get a message to the detective that had reached out to you previously?
Yes,
And what were your intentions with the detective?
Objection to relevance, Your Honor.
Overruled.
You can,
to tell the truth.
okay. So did you wanted to speak with him, is that correct?
Yes, ma'am.
Okay. And did you speak with him once you came back to Dare County, Texas?
Yes.
And at the time that you spoke with him, did you have a plea agreement in place?
No, I didn't.
And did you know that when you were speaking with him, there was a risk that you could be in trouble and charged in the offense?
No.
And you still decided to speak with him?
Yes, ma'am.
Okay. And I mean, the detective did warn you that anything that you say or said at the time could have
Objection,
been.
hearsay, leading.
Sustained.
Move to instruct the jury to disregard.
Disregard what?
And motion for mistrial.
What are you instructing the jury to disregard?
Her question, Your Honor.
All right, ladies and gentlemen, you're instructed to disregard the question.
Not motion for mistrial, I'm sorry.
Denied.
Did the defendant ever reach out to you to try to get you to say something specific to the detective?
Yes.
And what was that?
Motions for mistrial is catching up with sidebars.
Objection, Your Honor, hearsay and relevance, we keep using the plural. And I don't know who's saying what. So I would object to hearsay and confrontation.
Well, Judge, my question specifically was, did the defendant, so it's a statement against interest.
The
Option is
answer
overruled.
plural.
Whereas I'm showing you it's been marked as State's Exhibit number 128 and State's Exhibit number 129. Regarding State's Exhibit number 128, have you seen this? And does it contain your name and signature on it?
Yes, ma'am.
And was this shown to you by the detective when you spoke with him in the Bear County Jail?
Yes.
And regarding State's, and is it a fair and accurate depiction of what you saw back then?
Yes.
And regarding State's Exhibit 129, do you recognize what is contained within the photo?
Yes.
And is it a fair and accurate depiction of the people depicted in the photo?
Yes.
And then that's for inspection, then State's offering 128 and 129.
As to 129, Your Honor, we would just object as to relevance. And number 403. As to 128, Your Honor, I'd like to briefly take the witness on guard before that.
Let me see the exhibits.
And we have a sidebar. I mean, you would think that a case that is 8 years old and that has been, I believe, this witness went into the plea agreement in December 2018, that pre-trial, 5.5 years of pre-trial, the prosecution could have told the defense, this is how we are going to use this piece of evidence. But apparently not. Hi, Dave. Yeah, this prosecutor is very sloppy. She elicits answers that demands hearsay. Often. Very often. Skip ahead.
You recognize. Now, regarding State's 129, you recognize the people contained within the photo.
Yes, ma'am.
When
And the
123
person
was
that
out.
picture, you know, who is that?
Taylor Beverly,
And who is that?
Taylor McIntyre.
And regarding
Yeah. Yes, Tater Salad. They prepped her well. And we might know damn well she don't remember any of this with that amount of detail. Without spoilers, some things may or may not be revealed during cross-examination.
Miss Beverly, is that the person that you previously testified that you're staying in Dallas with?
Yes.
And the state offers to exhibit 129.
All right, with regards to State's Exhibit number 129, defense's objections are overruled. State's Exhibit number 129 will be admitted. And ladies and gentlemen, I'm going to give you a brief break. And I will have you all back here by 3 p.m. Remember my previous instructions, you're not allowed to discuss anything that you've heard in the courtroom. You're not allowed to do any investigation. You're not allowed to start deliberating with yourself or with each other. Does everyone understand? All right, everyone, please rise for the jurors.
All right, let's see when they come back here. Dun, dun, dun. Hi, Ronan says, I'm still missing what the prosecution needs to prove.
31. Okay, and you've identified.
There doesn't seem to be a question that the defendant was in car and then victim was shot by someone in the car. Yeah. Here's the thing. The other three people in the car are all pointing the finger at the defendant. But in Texas, that in itself is not enough for a conviction. There has to be corroborating evidence. Has to be. That is why they have all these witnesses on day 1, 2, 3, and 4 who are supposed to corroborate the snitches' stories. But in this case, since everybody's pointing the finger at him as the active shooter, they have to first prove that it was him who was the active shooter, and that also that counter the defense self-defense theory. And so far, most of what we have seen is crime scene photos, medical examiner photos of the victim, a lot of them, and witnesses. So far, we haven't actually seen anything that puts the gun, well, besides the testimony, but no physical evidence that says the defendant held the gun. So there are some, well, this is a jury trial, so even though they are told you can't convict because if you don't find anything, it's hard to not. Even though purely by the rules, there is very, very little that actually puts the gun in his hand. Cocaine stripper caught my eye, says Jonsi. Yeah, this will come out during cross-examination. We already know she was a stripper. We already know that she was 19 at the time. And we also know that she was in a relationship with a minor, the defendant, at the time. And we know that she was in the car. So, yeah. But for this testimony, she walks. Now, she got, I believe, 10 years probation, whatever it is. And so after she testifies, she might have 1 year left of that. So 1 year probation instead of being charged with capital murder. How about that? Theoretical, hypothetical. Would you, if you were charged with capital murder, even if you know you didn't have anything to do with it, and hey, I wasn't there. Yeah, but if you testify against that guy, we won't charge you with capital murder. You will just get a year probation. Would you testify in a court? I mean, I would like to say that I wouldn't, but the prospect of spending the rest of my life in, well, now I'm at the age I might as well, but but what would you do as a 19, 20, 21, 22-year-old? Hey, life in prison, or say something bad about this guy. What would you do? That is why if they had the evidence against all the people in the car, why not charge all of them? Why not charge all of them? Because it was, according to the evidence, it was a robbery. At least that is what they claim. There are, he has injuries that corroborates there was a struggle. There are witnesses who says it was a struggle, and then boom, you have he was shot. Why not charge all of them? Why do you so desperately need 3 people to snitch on one person? To let 3 people walk, who you might, as a prosecutor, argue they were all in on it. Yeah, I know they give deals to make the case stronger, but they have already a lot of witnesses who saw this happen. They have everybody's DNA and fingerprints and everything in the car. You have descriptions of the people in the car. How much that in itself is quite strong. I think it's not as much as it is a stronger case, but it's easier for a prosecutor to argue all of this against one defendant than against 4 defendants. I think it's plainly laziness in this case.
These photographs is one of Jalen Bell and one of Jeremiah Rodriguez, correct?
Correct.
And again, similar to what we talked about with 120.
Yeah, this is not in front of the jury, by the way. I think.
128.
128, I'm
Yeah,
sorry.
it's not in front of the jury.
These are the only photographs of that you were shown when you asked for each of their identities, right?
Correct.
You were not shown a lineup for either of these people.
No.
Okay. And to be fair, you know Jalen Bell, you know him from prior interactions, but you've had fewer interactions with Mr. Bell than you have with Mr. McIntyre. Fair to
The
say?
same amount.
Same amount? Okay. And then Mr. Rodriguez, you said you were acquainted with him in high school, but that you all didn't hang out a great deal.
Correct.
Okay. Your Honor, my objections would again be these are suggestive lineup photographs, and we would similarly object to hearsay and bolstering the way we did for.
All right, with regards to those 2 exhibits, and I'm sorry, what are the numbers?
130 and 131.
With regards to 130 and 131, the objection will be overruled. All right, Deputy, if you would have the jurors come in, please.
Yeah, I agree with Starfish here. They are making an example of him. And also, it's easier because he's already convicted of another murder, spending 55 years in prison for that one. So that in itself is easier. Now, I've been asked by people to check that case out because it seems to have some issues as well. Hey, Ronan says, I appreciate you taking the time to answer my question. Hey, I try. If I can, I will always try to answer questions. Also, if I see the question. Okay, skip ahead.
Great, I'm showing you what has been marked as State's Exhibits 130 and 131. Do you recognize these documents?
Yes, ma'am.
And regarding both of the documents, is this your name?
Yes, ma'am.
And is it your handwriting?
Yes, ma'am.
And is this a fair and accurate depiction of what was shown to you by a detective with the San Antonio Police Department back on September 5th of 2017?
Yes, ma'am.
At this time, Your Honor, the state offers State's Exhibits 128, 130, and 131.
Same objections, Your Honor.
All right, defense, your objections are noted. States Exhibit 128, 130, and 131 are admitted.
Permission to publish them.
Granted.
Mr. Reyes, regarding State's Exhibit 128, can you explain to the jury what this is?
Tamar McIntyre.
And is that appearance of Tamar McIntyre in State's Exhibit 128, how he looked back in 2017 when the offense occurred?
Yes.
Regarding State's Exhibit number 130, can you explain to the jury who that is?
Jalen Bell.
And regarding State's Exhibit 131, who is that?
Jeremiah Rodriguez.
Now, earlier in your
How
testimony,
is this not?
you testified,
Because she's already
regarding
pointed them
your-
out on other photos.
Can you describe the relationship that you had with Tamar McIntyre to the jury?
And,
Your Honor, I'm going to object relevance, and if we could approach the
Yes.
bench.
And we have a sidebar. Makes this sidebar number 24. So we are up on day 5, 24 sidebars and 10 motions for mistrial. Oh yeah. Hi Oxy, good to see you.
Good. Right, so this is a hearing outside the presence of the jury. The defense states that they believe that the answer is going to elicit 404B information. So first of all, state if this is going to be 404B, has the defense been given notice?
Well, Judge, I mean, they were given notice of it in the previous testimony that the transcript that was provided to them, that this testimony is contained therein,
Oh, please be seated.
and in her statement that she gave back in Clinton.
They have not filed formal notice to answer the court's question. But I mean, certainly this, parts of it are discussed in just vague terms in the transcript.
All right, so let's do this. Let me hear your questions. Let me hear her answers, and then I'll hear objections.
All right. Ms. Reyes, without going into specific instances, can you just briefly describe
Oh,
the
this
dynamic?
is a good question. Of age, homegirl, basic female. So is it definitive that the victim jumped on the car to avoid being run down, or did he do it to keep the culprits from driving off after they robbed him? We don't know because they were he jumped up on the hood of the car at the red light. Then it became green light. He was still on the hood of the car. They drove into the Chick-fil-A, where the victim stood up and started stomping on the front windshield until it caved in. And then he was shot. The reasoning, they claim he wanted his stuff back because the alleged robbery that took place in the car.
In the relationship that you had with Tamar McIntyre.
He was possessive and abusive.
And when you say possessive, can you explain how so?
Anytime I would enter a room, if there was other men in the room, he made me sit on his lap. I had to wear his clothing down to his underwear.
And when you say abusive, can you further explain that? Well, I'll just move on from that. That's it then.
So this adult at the time was with his 15 or 16-year-old at the time. I believe 16 at the time. Yeah, I mean, it's possible. But I don't know. I don't want to be inflammatory against her because of her profession. Maybe she was in that profession as a stripper and doing all the drugs because of other things that happened. But I have a hard time. He made her wear his underwear. Yeah, or the other way around. I've had girlfriends when I was a teenager who frequently stole my clothes. Just because it's more comfortable. So,
right.
yeah.
Do you have any questions with regards to that subject matter? And then I'll hear whatever objections you have.
Well, Your Honor, I mean, I guess that question and that answer would not actually be 404B because there's no elicitation of a specific instance of conduct. So it's just character evidence generally. Those traits of character are not relevant to the questions that the trier of fact have to answer, which is whether he intentionally and knowingly killed Mark Anthony Saldivar in furtherance of a burglary or of a robbery. And so I don't think that it's proper character evidence. I don't think that the predicate has been laid. I don't think it's relevant. And so I would like the court to exclude it on that basis. If the court disagrees, then I would like to engage in some questioning to try and determine whether or not, because the problem with the way that this is set up is the prosecutor is just asking generally, Mr. McIntyre a possessive bad boyfriend? Is he aggressive with you? Does he put you in fear of your life because of the way that he acts around you when you see other men? And the only way for us to cross-examine or impeach that line of discussion is to go into specific instances of conduct. And so it's almost a bait and switch the way that that's being proposed, which is why, I mean, I really do believe that's just not admissible character evidence. It's not an appurtenant trait of character for the offense. And there's been no foundation as to why it's relevant. I mean,
Okay, so
witnesses-
let's start with this first. Why is it relevant?
Judge, well, it goes to her credibility, and that was attacked by them in their opening statement. And so the reason that the state is offering it is to prove, well, not to prove her credibility, but to lend credence to her credibility and rebut their opening statement regarding their attack on her credibility.
that's just 404A1, prohibited use. I mean, that
Opening statements is not evidence. So why counter something that isn't evidence?
that's explicitly what the rule is designed not to allow them to do.
Well, Judge, they argued in their opening that she was being paid off for this. And so I think this line of questioning and testimony goes to something that they're about to attack on their cross-examination as to why she didn't speak out in the months between the offense and when she gave her statement in September.
I don't think anything in our opening automatically would authorize them to violate 404A1.
Time out.
And-
So this is what the court is going to do. With regards to this line of testimony, for the moment, the court is going to sustain the defense's objection. And if the door is open to something else, then the court will hear it. So,
Thank you, Judge.
all right.
Thank you.
All right, let's bring the jury in.
Well, I guess, if Your Honor, just to avoid a three-peat of this, are there any other similar subject matters that the state intends to get into so we could just knock those out and not have to bring the jury back in and send it back in,
About this particular witness or the next 12?
this particular one?
Well, I'm moving on from the subject matter.
Okay, so there we go.
Yeah. Prosecution keeps trying to get into things that they know aren't admissible. I mean, we have all the motions for mistrials are regarding, they are eliciting hearsay from witnesses. And they know they can't ask that type of questions, and they keep doing it.
I was wearing Florida Gator. I want to know, are these fair weather fans or?
Alias is at Alamo though.
Oh, well, Cornelius sent me a photo. He's holding a baby gator. So,
He's going, right?
oh, he was at the game.
Okay, but is he going tonight?
Oh, I think so.
Alright.
Let me just.
Thomas is, if I can.
Yeah, if you can approach. Just 1 second, Deputy Dewar.
That'd be great. Come on, come on. Cool.
So you see-
He comes back missing a finger, I'm gonna laugh.
Oh, I am too. It's like, and you know what? It wasn't even necessary for him to miss a finger, but he made it.
You always have to carry a clock with you too, if you lose a finger.
Oh, there you are. I remember that. All right, if you could bring the jurors in.
All right, for the jury?
All right, everyone, please be seated and state it's still your witness.
Of age, so says, so the adult at the time is claiming to have been forced into the situation and is effectively walking from charges while the teenager at the time takes all the blame. Yeah. Now, defendant may or may not have been not the best of people, but that's besides the point. That's really besides the point. That witness was legally an adult, and she was in a relationship with somebody who was legally a minor.
Counselor, I'm showing you what has been marked as State's Exhibit number 118. I'm gonna take it out of its envelope. You recognize this?
Yes, ma'am.
What is it? Well, how do you listen to the contents of this disc?
Yes, ma'am.
Okay, and regarding the defendant, were you familiar with him back in 2017?
Correct.
And have you spoken with him on multiple occasions?
Yes.
Would that include in person and on the phone?
Yes.
And when you listened to the contents of State's Exhibit number 118, did you recognize the voice that was making the call on State's Exhibit number 118?
Yes.
And whose voice was that?
Tay-K's.
And we have the witness now.
All right, defense, you may proceed.
Good afternoon, Ms. Reyes. So
Yeah. Now we are. I mean, for I mean, this is not This is not a YSL trial. The witness is fairly responsive in her answers. She is doing what the prosecution tells her to because she does not want to spend the rest of her life in prison. Regardless of what happened or didn't happen, she got a plea deal. She's going to do everything she can to not go to prison. Who wouldn't? But here we go with cross-examination, and some things here might be revealed. Let's just say that.
let's start off with your plea deal in this case. You pled to tampering with evidence, correct?
Correct.
That's a third-degree felony.
Yes, sir.
What is it that they said you tampered with?
The car.
The car?
Yes.
Okay. And in exchange for that, you got the capital murder charge pending against you dismissed, right?
Correct.
And you were allowed to remain out on bail this whole time, this past 7.5 years, right?
Correct.
And the agreement is that if you satisfy the terms of your deal, then you'll get what's called deferred adjudication, right?
Correct.
And you understand deferred adjudication means that you would not be finally convicted of that felony offense, tampering with evidence, right?
Correct.
Which means that if you successfully complete your deferred adjudication, you can petition the court to non-disclose the record, right?
Correct.
Meaning that other than police and perhaps the judge, the members of the general public that might want to employ you or give you an apartment or anything else would not necessarily know that you were ever convicted or never admitted guilt to defer tampering with evidence, right?
Correct.
And
Yeah. So within this plea deal is if she doesn't fuck up, nobody will ever know she was ever involved in capital murder where she pled out to a third-degree felony. That is a sweetheart deal. I believe that she would have pled to 2 to 5 years in prison just to avoid life in prison. But they actually gave her a deal where she is free to go, and then if she doesn't fuck up, nobody will ever know.
the condition for you getting this deal was that you would testify truthfully against Mr. McIntyre, correct?
Correct.
And you understand when they say testify truthfully, that the person who decides whether you're being truthful is the district attorney's office, right?
Correct.
So if they think that you're not telling the truth, then they would be able to tell the judge that, and it could impact your case in a negative way. You understand?
Yes, sir.
And you also understand that if you are placed on deferred adjudication, you're eligible for what's called early termination of that deferred adjudication, right?
Correct.
And early termination can be applied for the day that you are placed on deferred. You understand that, right?
Yes, sir.
So it means that if you testify to the prosecutor's satisfaction in this case, and you are sentenced to deferred adjudication, as you said in your agreement, you could apply for early termination that day. You understand that?
I'm gonna object as to relevance. It's a misstatement. He needs to read the agreement because that's not what's contained in therein.
Your Honor, it's plainly part and contemplated of what a deferred adjudication is, and she knows what early termination is.
But is it a part of the agreement? That's the state is saying that it's not a part of the agreement.
Does the agreement say that there's no opposition to it? You have 1 second. 1 second. Okay, so let's call your attention. Is the Elmo work?
It's ready. It's ready.
Yes, please. 9 and 10. Yes. All right. So on paragraph 9, it says the state will agree that at any time served on bond while awaiting sentencing without violation of bond conditions will count towards the deferred recommendation time, and the state will adjust the recommended time for deferred accordingly. For example, if your client, or you in this case, spends 2 years on bond from this date without violating the conditions, the state will recommend 8 years of deferred instead of 10 years at the time of sentencing. You read that part?
Correct.
And how long have you been on bond for this case?
Almost 8 years this month.
Almost 8 years this month. So the result of that is that if you have satisfied the state's expectation that you testified truthfully, at the conclusion of this, I guess you'll have to spend another year on deferred adjudication before you'd be eligible to request that you receive early termination. You understand that?
Correct.
I'm going to object to speculation and relevance.
Well,
All right, with
number,
regards
paragraph
to-
10.
With regards to speculation,
Well, Your Honor, I'm just asking her what her understanding of her own plea agreement is, which goes to her bias and motivation, which is an admissible question.
all right, could parties approach?
And we get a sidebar. And we get another sidebar, which gets us up to sidebar counter 25. On day 5, sidebar number 25. Wow. 25 sidebars, motion for mistrial 10. Yeah. Skipping.
Paragraphs.
All right, defense, you may proceed.
All right, Ms. Reyes. So to go back to paragraphs 9 and 10 of your agreement, you understand you've been on bond for 8 years, right?
Correct.
And you understand that under this agreement, so long as you're testifying to the prosecutor's satisfaction, they're promising to give you a discount on the total 10-year period of deferred for each year you served on bond in their recommendation to the court for punishment, right?
For the truth, correct.
And that you must spend half of the total time on your deferred before you can apply for early termination, right?
Correct.
And that would only be a year, given that you've already spent 8 years on bond, assuming that the prosecutor does recommend that reduction and assuming the court accepts it, right?
Correct.
Okay. And you understand that there is no statute of limitations for capital murder, right?
Correct.
And so if you testified in a way that was not to the prosecutor's satisfaction, you understand that you could still be prosecuted for this capital murder offense, correct?
Correct.
And you understand that 10 years is the maximum for the third-degree felony, correct?
Correct.
But it would be life in prison without the possibility of parole for you if you were to be charged with this capital murder offense, right?
Correct.
Now, when you first met with Detective Juarez, it was in September of 2017, is that right?
Correct.
So about what is that? I'm not good at math, like what, 6 months or so after the offense?
Correct.
And during that time period, you said that you went to Dallas, you were in Ector County, which is Odessa for a little bit. That's where you got arrested.
Correct.
So you said that you met Tamor about a year and a half prior to this offense,
Correct.
and he was 15 years old at that time, wasn't he?
I didn't know his age at the time.
Well, I'm asking.
When they met, he was 15. And she was legally an adult. And she's, oh, I thought he was 18. He was a tiny, scrawny kid. He was your height and thin as a stick when you met. And you still decided, hey, I'm going to screw with this guy. With this boy, with this kid.
If you know that now.
Yes, no, I do.
He was 15 when you first met him.
Correct.
And he was 16 years old on the 23rd of April in 2017, right?
He lied at that time, said he was 18.
But you understand he was 16 years old, right?
No, I do, yes.
You met him at a gathering through Isaac, which was your boyfriend at the time.
Correct.
But then you started dating Tamor in the 2017 timeframe, correct?
Correct.
And you said that you were acquainted with Jeremiah Rodriguez because you went to high school with him.
Correct.
So you knew that Jeremiah Rodriguez was a drug dealer, right?
Correct.
And you knew that he often carried weapons, correct?
Correct.
you said at the time period you were dancing at a strip club,
Correct.
and the weekend of this incident, I believe, coincided with the Stoner's Holiday 420. Is that right? April 20th,
Objection, relevance, and
Relevance.
personal.
if you know.
Relevance.
Well, I'm trying. The relevance is, I believe, what they were doing at that party, as it relates to what happened later, and it relates to.
All right, you'll need to lay the foundation with regards to time.
Was there a party the weekend of this incident that you attended with Mr. McIntyre and others?
That weekend, no.
Okay, but you and Mr. McIntyre and Mr. Bell were all hanging out.
We were together, yes.
Was Jeremiah with you?
Yes.
But you weren't staying at Jeremiah's house that night before this incident, were you?
Yes, we were.
Okay, are you sure of that?
Very sure.
Okay. If Jeremiah disagrees with you, Jeremiah is not telling the truth.
Correct.
And you all took drugs that night before, didn't you?
I didn't, they did.
Okay, well, you say you didn't. Let's be more specific. They took LSD, didn't they?
Yes.
And you didn't take LSD.
No,
You smoked marijuana, though, didn't you?
I was completely sober.
You didn't smoke marijuana or do cocaine?
No, not the day before.
Are you sure?
Yes.
But you had done them in recent time frame.
Previously, yes.
Okay.
She claimed this cocaine stripper claims, no, at that exact time where everybody else is partying with LSD and other things, no, at that very point you decided, no, I'm going to be very extremely sober. Seriously? 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 The weekend 420, the 420 weekend, you, cocaine stripper, decided to go sober. That very weekend.
And so, Mr. McIntyre and Mr. Bell would have taken the LSD sometime in the evening hours of Saturday night before this event on Sunday, right?
Correct.
Okay. And do you have any experience with taking LSD?
Yes.
You're aware it's a very long-lasting drug, right?
Correct.
So it may not be that they were acutely intoxicated, but there would still be effects 24 hours later, you know?
Objection, speculation.
Sustained.
In your experience, you could still be having effects from it 24 hours after the fact, right?
Yes, but it didn't seem like that.
Okay, I'm not asking you what it seemed like. I'm just asking what your experience with that drug is.
Yes.
So that night before, there had been a conversation about a photo shoot. Part of that was to promote your career as a dancer, wasn't it?
No.
Okay. You say it was because Mr. McIntyre was wanting an album cover,
Correct.
but you're aware that Mr. McIntyre has a producer and that he has people that do photo shoots for him and that all of those types of things?
Objection,
If you
relevance,
know.
and
All right.
speculation.
The state has objected to relevance.
Well, it's relevant because I'm just asking her if she's aware. It goes to whether or not she understood the framing of this correctly.
All right, that objection will be sustained.
So,
It was
You
a badly
contacted-
asked question.
Mark, through Instagram, right?
Correct.
And Mark had contacted you previously on a different Instagram account of yours, right?
Correct.
And had asked if he could take photographs of you, right?
Correct.
And the kinds of photographs Mark wanted to take to you, I'm sorry?
I'll let you finish the question.
The kinds of photographs Mark wanted to take of you were either nudes or risque photographs, wasn't it?
Judge, I'm gonna object and if we could.
Yes.
We have a sidebar. Sidebar counter 26. Yeah, she may be a PDF stripper, but that evening, I'm going sober. I'm going to be a saint. Oh. Ronan, I see you are a man of culture. Yeah, first best, this may go to a motivation for testifying. Yeah. Yeah, let's skip.
Defense, you may proceed.
Right. So what we were asking a moment ago, Mark had reached out to you on a prior occasion, and the discussion was about whether he could take nude photographs of you. Do you recall that?
Yes.
And when you looked at Mark's Instagram page, you saw that most of his photography work was of that variety, naked pictures.
Yes.
And because of those things, you had blocked Mark previously, right?
Yes.
And then you had activated a new Instagram account, and that's how Mark got a hold of you on this occasion, right?
I had that account for a while.
Okay, but he resurfaced as an Instagram correspondent
Correct.
on a new account, right? And on this occasion, the discussion was displaying you in lingerie, correct?
Yes.
And so those were the circumstances that were going on during the evening hours of Saturday leading up into Sunday. We're making arrangements to have this photo shoot where you would be in lingerie, correct?
Correct.
All right. And you said, I believe on direct examination, that he had agreed to do this for little or no pay, right?
Correct.
And so you all were thinking about doing the shoot somewhere near the North Star Mall.
Correct.
Okay. And when you arrived, he walked out from his house and he got in the car and he saw that it was you, Jalen, Tamor, and Jeremiah, right?
Correct.
And that wasn't something you had explicitly discussed with him before, was the fact that there'd be other men there, right?
How about that? You did not like this person to the extent that you blocked him. And this person still, when you started this new account, then he reached out to you again. And all of a sudden you decide to, yeah, let's do a photo shoot. And you show up with 3 other guys. Isn't that strange? Folks, isn't that strange?
Tamar was gonna be,
You didn't know anybody else was going to be there, right?
and we said multiple people.
Okay, when did you tell anybody that?
But we text.
Let me
And we
back up.
communicated with them.
Let me back up a moment. You have given statements to the police in conjunction with this case, right?
Correct.
And you have given statements under oath when you entered your plea of guilty to the plea agreement, right?
Correct.
And you didn't tell anybody that you had explained to Mark that there would be a bunch of men present at the photo shoot, did you?
No.
So Mark gets in the car, and immediately, once y'all are rolling away, the photo shoot's called off, right?
He asked to reschedule for a later time that day.
Oh, so he gets in the car and all of a sudden, hey, I need to reschedule. Oh. Seriously? 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 Doesn't all of this to you guys scream setup? Folks. And set up by whom? Could the setup be from PDF cocaine stripper? Who, in exchange for testimony, will walk free? With the possibility to have everything about this case removed.
Okay, that's calling off the photo shoot, isn't it?
It's rescheduling.
Okay, so y'all were still driving away with him, right?
Correct. He asked for a ride to North Star.
And you told the detective that you were confident Mark's intention was to have sex with you that day, right?
No.
You don't remember telling the detective that?
No.
But it's refresh your recollection to look at your statement to the detective.
We can.
So, this is a guy who you blocked. But all of a sudden, you create this new account and he reaches out to you again and still not only wants to take nude pictures of you, but he wants you for sex. And you show up with 3 more guys for a photo shoot. And all of a sudden, you, Miss Reyes, who had perfect recollection during prosecution's direct examination, suddenly have no recollection whatsoever, not even what was in your plea deal, what you actually testified to. Isn't that strange? Yeah, as Ichi says, not just this witness from yesterday, but also other testimony from the investigators. Yeah, I agree. Something is very off here. I can say already, here's my theory. She wanted him beaten up. So she set the victim up. They got him in the car, started assaulting, and then he did something they didn't count on. He jumped on the hood. He stomped the windshield, and then gun went off. Now everybody's pointing at the person who is already serving 55 years for another murder. Folks, isn't that strange? Everybody who testifies who was in that car will walk as long as they point the finger at the guy who is already serving time. And I have doubts regarding if Tay-K actually knew what was going on. I have serious doubts about that. Because she might have dated him. But I believe that she and the other two in the car were in on it. And Tay-K seems to have been a bystander of some sort. Just caught up in the moment. Let's continue. For you who wonder, yes, I'm going to cut out the cross-examination of her without all the pauses and things to a separate video.
Number 9. Reyes, let me give you this transcript. I want you to kind of look it over. And if you have any questions that you would like to refresh your recollection from it, please let me know. I'll be asking you some questions from it too. We'll have copies.
Judge, I'm going to object to that exhibit. It's not written.
I haven't offered it, and I'm just giving it to her because she said it might refresh her recollection, and if it doesn't, it doesn't.
You just need to know the design of it.
I was just giving you a copy.
I'm objecting to lack of foundation. It's not written.
I'm giving you a copy of it so you can tell me what it is. What do you mean it's not understandable? I'm not offering. All right. Ms. Reyes,
Right, so a party's approach.
And we have a sidebar. Sidebar number 27. Sidebar number 27. John C. asked, why is the state offering her this deal? Because they want an easy conviction. That's my only answer. Hi, Rhonda. Good to have you here. Good to have you here. Good to have you here. Let's see, how long of a time do we have to... Oh.
Transcript, the defense is saying. Transcript, the defense is saying it's transcript of the witness's statement. State, have you had a chance to review that, or have you seen that before today?
No, Judge.
All right, so this is what the court wants the state to.
Yeah, here arises an issue because their transcript is from the hearing, but it is not an official transcript. It's not the court's transcript of that videotaped plea hearing.
To review that. And if someone can show her, defense, if you're saying this is a transcript of her actual video statement, is that correct?
That's correct.
All right, so if someone has her video statement, if you all will please show her her video statement. And defense, whatever you want to prompt, if it turns out it's for impeachment purposes, if you can do your time steps on her video to show that to her for any reason you believe it's impeachment evidence.
And Your Honor, specific to what this question and answer is about, I can call the witness's attention to the 50-minute and 39, or I'm sorry, the 50:39
All right, so
mark on the video.
here's the problem with that. If you all want to go to the video and specifically show her that portion, then if somebody will go to the video and show her that portion of the video.
I have that portion ready for the court, Your Honor, but I just wanted to, I mean, at this phase of it, all I have asked is if the witness recalls her previous statement, if it would help her remember to have a copy of her transcript in front of her.
But see, the problem is the transcript that you're saying that is her transcript. That's not an official transcript. My understanding, if I am wrong, correct me, my understanding is that is someone that the defense, I guess, hired, or someone that the defense had to take her video statement that she gave to, authorities and have them watch that and do a transcript of it. Am I correct?
Well, yes, but the problem is, Judge, we're talking about two separate rules of evidence and application. Right now, at this moment in time, all we're dealing with is past recollection refreshed. And if I had a cardboard cutout of Mickey Mouse that would refresh her memory, then I could show her that. That's all I'm doing, whether it's an official
Well, let me ask
transcript or
you
not.
So here's my question to you, because that transcript is not an official transcript. So you're trying to refresh her memory. So let's assume it doesn't refresh her memory. Then what's going to be the next step?
I'm going to ask her if she said on a prior occasion, and I'm going to recite what I believe she said. And if she says yes, then that ends the
But
discussion.
what if she says no?
Then we have the video clip to the
So
exact.
why don't we just show her the video so we don't have to take the jury back and forth outside? So just show her the video.
May we confirm for a
Yes.
moment, ma'am? She's up with us.
Sorry. Yeah. Then they take a break. Da 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 da. And as you see, all of a sudden,
So the jurors have went home. We are going to start tomorrow at 1:30. On Wednesday, we're going to start at, on Wednesday, we're going to start at 9 a.m. Thursday, we're going to start at 9 a.m. Friday, we're going to start at 9 a.m. All right, and I've had my
okay, so now we know when they are going to start. Now, what happened with this is she wouldn't allow the transcript to be shown to her as does this refresh your recollection. The video and the entire video was shown to the witness, which I believe was wrong. And why do I believe that? Well, because now they can't impeach her. Now she knows what to say again. Now she can. So more or less, she got, unless she forgets again. But now the element of surprise is gone. I believe this was the wrong call from Judge Boyd. So, in my opinion, because the reason they had a transcript of that hearing was because if they asked the court for a transcript, then they would have, then the prosecution would have known about it and could have prepped the witness. They wanted this unprepared witness in front of the jury. regarding these specific questions to catch her in more lies. Sadly, now that element of surprise is gone. Sadly. Now, as you heard her, today they are going to start 1:30 Texas time. That is in 2 hours. So, and that means cross-examination will continue today at 1:30 and will probably continue for some time. The sad part is I don't have time because it's spring. We need to get out on the fields. We have spring sow, and we need to. For you who don't know, hi, I'm Nick. I'm a jurist. I do labor law. I also have a farm. I have 46 acres that needs tendering now when it's spring. So I need to take care of that. But what I will do is I will return tomorrow morning, 9:30-ish Eastern time, with the rest of this cross-examination. Because it will be amazing. Can you see do you want to see the fields? Yeah, sure. Hold on. I'll show you. Let's see. There. Sorry for shaking. I'm really stretching myself here. So there. Ta-da. And, oi. We got Dave. Hi, Dave.
Hello. I just came in here to harass you and say that you're not going to go work the fields. You're going to go kick back with a cigar and drink some scotch and enjoy this sweetest summertime. This is the warmest it's ever going to get there.
I wish I could. Now, you have been listening in. Yeah. What's your opinion about this witness? And my theory about what might actually have happened.
Well, I think she has every reason in the world to lie. We saw this a little bit with the Crumbly case after the fact, where the two key witnesses in that case were offered proffered agreements like, hey, we're going to give you immunity if you testify in a way that's favorable to us. And it sounds like that's the very deal she got here, which is 100% a credibility issue. Now, the last thing was showing the transcript to impeach as opposed to the video. And that's very interesting because it sounds like the transcript was made from the video.
Yeah, it was made from the video, but it wasn't an official transcript. And I think that is where, because you could show a witness a ham sandwich as long as it refreshes their recollection. So But this might be a Texas rule that Judge Boyd applies.
I don't know if it's a Texas rule. I see where the judge is coming from with this particular issue. Hang on a second. Let me move. My printer is being really loud. So I see where the judge is coming from. So let's assume they use it to refresh her recollection, right? And then let's assume it doesn't refresh her recollection. Like the judge said, where do we go from there?
Yeah.
And then we have to show the video because the transcript, whether it's official or not, it might convey different meanings, right? This is a transcript of a video, which I use all the time in motions, not in trial, but in motions, because I don't want the judge to have to read or watch the videos necessarily. I want them to be able to just say, read a certain segment of the video transcript. So I get where the judge is coming from, although what it does is it hampers the defense's strategy. Right? The defense should be allowed to present the case as they deem appropriate. And so while I understand the judge is like, well, we don't want the jury on and off and on and off and on and off. That's fine, but that affects the defense's strategy, which is a problem.
Yeah, I do believe this will become a problem because now the witness will be prepared. She might she might have tried to lie again or claim she didn't remember or try to get away. Now she knows what she said in that video.
Yep.
And that really.
So Yeah, I mean that hurts the defense's strategy. That's
Yeah.
that's the biggest thing that I don't like about it.
Yeah, because as of now, because in my opinion, the prosecution is using Tay-K or Mr. McIntyre. He's a good scapegoat. He's already in prison. It's an easy case to win.
Yeah,
It really is. I mean, there's enough evidence, but then you have these Texas rules about, here's the three snitches, but they can't corroborate. They explain this on day one during opening statement. They can't corroborate the snitches' testimony with the other snitches. They are not allowed to. There has to be separate corroborating witness with either testimony or hard evidence.
this is the big one that I think the defense was talking about in the opening statement.
Yeah,
Now, this witness has every reason to just say whatever the state wants her to say,
yeah,
and that's going to be a problem. Although I don't think it's going to be enough of a problem that alone will lead to an acquittal.
no. I mean, they need something from the other two that really speaks against, because this woman, I mean, I believe this, as I explained earlier, everything here points to this was her setup against this guy.
This is a good lesson, people. Careful who you hang out with. Let's
Yeah.
assume this defendant was completely innocent, but everybody rolled over on him. And
Yeah.
the only reason he's being charged and is going to be convicted is because he was in the wrong place at the wrong time with the wrong people.
Yeah. For all we know, he was asked by his girlfriend, his older girlfriend, to, hey, come to the car. We need another guy. And he just sat there going, what's going on? What's going on? And somebody thinks him doing this. Oh, he had a gun.
Yep. Yeah, just don't put yourself in those situations, people.
But this guy was 15-year-old when he met a stripper. I mean, jackpot.
I have a buddy I went to, well, not a buddy, a kid I went to high school with that right after high school at 18, he ran off with a stripper. And his life has been a living hell ever since.
Yep. Don't stick your dick in crazy.
That's right.
Yeah.
Holes is not always the best holes.
Yeah, and this, when she tried to say, oh no, she was completely sober on 420. Yeah, sure.
I'm sure.
I mean, you never know with jurors, but I think that kind of, yeah, we don't believe that. And also,
Don't sit in the back of the car. Yeah, that's the other thing too. Don't sit in the back of the car.
yeah, and
In the
again,
middle, in the
yeah,
back.
and again, when they interviewed her in 2017, they knew she, according to Texas law, had committed statutory rape.
Well, they're going for bigger fish here.
Yeah. So yeah, I mean, but the rest of the cross-examination will be interesting. Even though they have to change tactics a bit, this witness, even though she is a liar, I don't know how good of a liar she is. How does she do under pressure?
You know,
Because
though,
so far she is not under pressure, a lot of pressure, and
aside
she still
from,
screws up.
aside from the 20-some motions for mistrial, this is a fairly normal-ish case that you
Yeah.
would see. This isn't anything terribly elaborate. This is the bread and butter every day of the judicial system. This is what we're dealing with.
Yeah, we have 27 sidebars and 10 motions for mistrial. And the motions for mistrial is because the prosecution keep asking questions that elicit hearsay. And it's so lazy. It's so lazy. Because all of these will be appellate issue. Now, this guy, Mr. McIntyre, is already in prison for another murder, 55 years. That happened roughly at the same time. But people in the chat have been telling me, you need to check that case because it really isn't what it seems to be. So I have to find that case and read up on it.
Yeah, that could be interesting.
Mm.
So, but
Yeah.
you're back tomorrow morning then with more of this wonderful
Yeah.
trial. The best thing
what-
is like the witnesses being able to see through the car.
Yeah.
That was
Every
ridiculous.
witness. I mean, the most credible witness so far is the homeless lady. I
Yeah.
mean, it's 4 p.m. Texas in April. The sun is beaming. Yeah, I mean, and the woman with the baby, yeah, or a toddler in her lap, who said in the car the car in front of the car where everything happened. No, she saw everything in that car behind her, with the toddler on her lap,
Yeah.
as a slightly large woman. She managed to turn all the way around with the toddler in her lap. I mean, seriously.
Well, this is the problem with human memory and eyewitness testimony and stuff like that, is that people will incorporate things that they've heard since actually seeing it themselves, and then they incorporate it. And it's not because they're doing it intentionally. It's the way the human mind works.
Yeah.
There's been studies on this. And so in fact, I was just watching a special on a Swedish crime where a young lady disappeared back in the 80s and was found unalived, and they did some police lineups, but everyone but the one suspect were police officers.
Yeah.
And then they later came out that the way they asked the questions and they had the people speak, the majority police officers speak, it was clear that they were hinting at and subtly suggesting to point the finger at this one particular suspect. But it's more, it's better studied now. And I think the guy got an acquittal. I don't know. I don't speak Swedish all that well, but I think the guy ended up getting his conviction overturned because of it.
Yeah, I vaguely recall. But, I mean, that kind of lineup was happening in Swedish all the way up to the early noughts. And...
Yeah, and so in the United States, when people are like real life cases now, they don't do people standing up in lineups. If they do anything, they do photo lineups of a series of people. But even that falls under a lot of...
Now, since the early noughts, we have completely gone away from sketches, more or less. It's extremely rare to have sketches. And the only time when they are presented, it is in these wanted. Have you seen somebody?
Yeah.
But as a criminal, as an investigative tool, it's more or less no. They are not because it's too unreliable.
And I have the same thing. Everyone does this, right? Think back to like one of your earliest memories as a child, or whatever, however far back you can think of.
Yeah, I saw some guy in white saying it's a boy.
But think about that, and is that really your memory? Is it the correct memory?
Yeah.
Or was it shaped by, say, like a family video that you saw more recently and things like that? And if you actually start to think about it, you're like, well, I got a ton of stuff wrong. And in fact, when I think about things, and then I like look at them later and try to like challenge my memory this way, a lot of my things are reversed. I didn't realize that. So I remember things almost mirror image. The human mind is weird.
Yeah, it is. But again, we have a case here where every eyewitness has perfect recollection 8 years later during direct examination. And
that is just simply them telling the story over and over, hearing other people tell the story over and over, and reinforcing this whatever sort of memory that they've created.
Yeah.
It's not very reliable.
Yeah. And by pure coincidence, everybody met with the prosecutor the week before trial. Isn't that strange? And during cross-examination is, no, I don't remember that. Yeah, but folks, thanks Dave for showing up. And thank you guys over at YouTube, Rumble, X for showing up. We will be back here 9:30-ish tomorrow morning, where we will go through this afternoon's cross-examination and whatever else happens. And because I believe the witnesses they have left are these 3 people, and then maybe the lead investigator to finish it off. So we might be on the last few days of trial here, because I'm not sure how much of a defense case in chief they can have in this. Maybe
I doubt very much, but we'll
yeah.
see.
Yeah, but folks, thank you again. Thank you for allowing me to do this, and I will see you. Or let's see, who can I redirect you guys to? Let's see who. Dun. Do you want to see baby goats? Yeah, everybody wants to see baby goats. I'm going to send you over to Valhalla to watch baby goats.
I should have put my chicken stream up before that.
Yeah, you should. Yeah, you should. All right. Thank you, everybody. See you tomorrow morning, and have a good one. All right. Bye-bye.
Sail the raven waves, brothers, axes high, shields strong. From distant lands we gather,